This hearing will come to order. Just for housekeeping, before I do my opening statement, we are going to have votes beginning at, I believe, somewhere between now and 2:45. I've instructed the cloakroom, unless my vote is needed to break a tie, that I don't intend to recess the hearing, so we'll charge through. But if I have to leave, it is, in fact, because I need to break a tie. Don't anticipate that. And I know that you all put a lot of work into this preparation, and I want to show you the utmost respect of not having your testimony and these discussions to be interrupted. Today we discuss a topic that I think in my time here has been often confused and mischaracterized, and I actually believe it's one of the most important issues facing our country today in the patent community. It's the topic of patent eligibility reform. The long overdue need for patent eligibility reform is one that if left unaddressed, will cede America's well-earned title of the global innovation leader and global intellectual property rights leader to other communities. Can't let that happen. And under my watch, which incidentally is over the next 452 days, it will be one of my top priorities in my office. The sad part about the potential loss of our, what I believe, championship status in the IP and intellectual property protection community is foreign governments like the CCP are actively working to undermine our IP system. And they're attempting to overtake America's position as the global IP leader. As I said before, there are those in this country who rather than fix the problem, would like to take advantage of ambiguity or, the comfort with the status quo that's been created because of the confusing and I think sometimes conflicting outcomes in our courts. Now, we have four relatively recent Supreme Court decisions that have caused patent eligibility law in the U.S. to be confused, constricted, and unclear. That's what we're trying to fix here, folks. It's led to inconsistent lower court decisions, uncertainty in innovation, uncertainty in investment communities, and unpredictable business outcomes, all things that, if you know me, I don't like. Research has confirmed that under the expanded judicial exceptions, U.S. inventors are unable to obtain patents in areas where economic peers offer protections. This is particularly concerning in the economically critical areas of biotechnology and computer-implemented invention, where patent restrictions decrease investment and send capital overseas. As of 2021, all 12 then-sitting judges of the U.S. Court of Appeals of the Federal Circuit Court lamented the state of the current law. I've always said that we should not rush to legislate and that we should let courts do their job until they don't. And that's where we are now. Case in point, in 2021, I worked with former USPTO Director David Capos, who we'll hear from today, and retired Judge Paul Michel to file an amicus brief in the American Axle case. I was disappointed to see the Supreme Court decline the opportunity to offer clarity on patent eligibility, so we still have a lot of work ahead of us. And while former USPTO Director Andre Iancu, who's also we'll hear from today, made great strides with the 2019 PEG, the revised patent eligibility eligibility guidance. It changed how patent examiners review patents, but the guidance is not binding on the courts, and when patents are challenged in litigation, the guidance lacks the force and effect of law. That's why I've introduced the Patent Eligibility Restoration Act of 2025, or PERA, along with Senator Coons. Earlier this year, I was happy to see Senators Blackburn and Senators Hirono join as co-sponsors. PERA preserves the first part of the current eligibility statute, but it eliminates overly broad set of 3 current judicial exceptions, replacing them with 5 specific, defined statutory exclusions. By eliminating and replacing the current judicial exceptions, PARA provides predictable patent eligibility for important computer-implemented technology developments and medical advances, creating a solid background for America's innovation future. It's important to note that patent eligibility and patentability are often conflated. This is a tool that opponents to patent eligibility reform, I think, often leverage to sow confusion and paint the narrative that expanding patent eligibility will equate to rampant and uncontrolled patentability. I disagree. Section 101 was not intended to function as a gatekeeper to keep out ineligible patent claims. Patent eligibility is simply one step in the process of determining patentability. Should a patent examiner find a claimed invention fails to meet one or more of the requirements outlined under Sections 101, 102, 103, and 112, a patent will not be issued. Simply meeting the requirements of Section 101 does not mean that a patent will be granted. I will remain a champion for strong, reliable, and predictable intellectual property rights and for inventors and creators, large and small. And as part of that promise, I will not stop shining spotlight on the need for patent eligibility reform. I'm also heartened to see that our current USPTO Director, John Squires, shares this understanding and that we need patent eligibility reform and that the status quo is not sufficient. This is no more evidence than by his ceremonial signing of 2 patents last month on technology generally considered not to be eligible under Section 101. I hope that this is our last IP subcommittee hearing on this topic and that we will soon move to PARA and a markup in this Congress. I will be entering my opening, well, I've already stated all my opening comments. I want to give Senator Schiff an opportunity to make opening comments, and then we'll also hear from Senator Coons. Senator Schiff.
Chairman Tillis, thank you for bringing us together for this important hearing on patent eligibility. As I do not have a Tillis rule, and as I am a freshman, I will be running off to vote. And as I have a resolution that may come up this afternoon, depending on where Senator Tillis is on that resolution, I may ask you to keep him here, especially if he is the decisive vote. The right to patent inventions is enshrined in Article 1, Section 8, Clause 8 of our Constitution. Even back in 1787, the framers knew it was important to prioritize and protect innovation. Over 200 years later, their foresight has cemented the United States as the worldwide leader in innovation. The Constitution grants inventors the exclusive right to their respective discoveries for a limited period of time. On that point, everyone agrees. Where experts, stakeholders, members of Congress often disagree is exactly what qualifies as a discovery. Thomas Jefferson believed that any new or useful art, machine, manufacture, or composition of matter, or any new or useful improvement thereof was eligible for a patent. In 1952, when Congress recodified Jefferson's original language, they swapped the word art for process in what we now recognize as Section 101 of the Patent Act. In Diamond versus Chakrabarty, the Supreme Court recognized Congress's intention for anything under the sun that is made by man to be patentable. Yet the court also wrote that this is not to suggest that Section 101 has no limits or that embraces every discovery. The Supreme Court has long recognized explicit limits on patent eligibility. Laws of nature, physical phenomenon, abstract ideas are not eligible for patent. The first miner to discover gold in the earth could not patent the mineral, and the first person to find an apple in the wild could not patent the fruit. And I speak with some authority on that matter, as I am Adam and I'm married to a woman named Eve. If you could patent the first apple found in the wild, we would own that patent. Similarly, Einstein could not patent E equals MC squared, and yes, my wife is actually named Eve. Einstein couldn't patent E equals MC squared. Archimedes could not patent pi. Pythagoras could not have patented the Pythagorean theorem. The courts have long held that these discoveries are manifestations of nature, free to all men and reserved exclusively to none. While it is important to have clearly established exceptions and guidelines around patent eligibility, Many inventors, patent attorneys, and even judges on the Federal Circuit, where the Appeals Court of Jurisdiction, which is the Appeals Court of Jurisdiction for patent cases, have bemoaned the current state of the law as muddled and unclear. 4 Supreme Court cases in the 2010s, Alice, Mayo, Bilski, and Myriad, have collectively created uncertainty around the patentability of various technological and medical innovations. In the middle of the artificial intelligence technological revolution, clarity and stability around the proper interpretation of Section 101 is necessary to ensure that America continues to win the international innovation race. It is equally important that biotechnology companies have clarity as they work to invent life-saving medical diagnostic tests and other treatments. As members of Congress, we must ensure that we are striking the right balance. If algorithms or technological inventions that simply duplicate pre-existing processes on a computer or on a chip are patented, it could have the reverse effect of stifling innovation rather than encouraging it. Similarly, if one company is able to monopolize a medical diagnostic test without guardrails, that could lead to less patients receiving proper treatment as opposed to more. It's our job to figure out the proper balance between encouraging investments in innovation and ensuring that as many Americans are able to reap the benefits of that innovation as possible. I look forward to hearing our witnesses today and learning more about the current state of patent eligibility law in the United States. I look forward to exploring the steps that we as members of Congress can take to bring much needed clarity to the law, and I want to express my gratitude again for Chairman Tillis and Senator Coons for taking on this extremely important but complex issue. And I yield back.
Thank you, Senator Schiff. Welcome to the witnesses, and thank you for the time that you've put into preparing for the hearing. We'll introduce you all and then ask you to, or give you an opportunity for opening statements. Mr. Cohen serves as a Senior Technology Fellow at the Asia Society of Northern California and at the Asia Society Policy Institute located here in Washington, D.C. Mr. Cohen previously served as the first USPTO representative in China and as USPTO senior counsel. In total, Mark has 40 years of private, public sector, in-house, and academic experience in China. Director Andre Iancu serves as a partner at Sullivan & Cromwell LLP and is a former Undersecretary of Commerce for IP and Director of the U.S. Patent and Trademark Office. Mr. Iancu has decades of experience representing plaintiffs, defendants in IP matters across the technical scientific spectrum. While director of the USPTO, he established the 2019 Patent Eligibility Guidance, which made great initial strides at providing clarity in the eligibility space. Mr. Capo serves as a partner at Kravitz, Swain, and Moore LLP, and is former Undersecretary of Commerce for IP and Director of U.S. Patent and Trademark Office. Mr. Capos covers a wide range of complex IP issues, including those pertaining to blockchain, crypto assets, and fintech, as well as cybersecurity and data privacy. As Director of the USPTO, he led the agency in re-engineering its entire management and operational systems, as well as an engagement with the global innovation community. I get really excited when you do things like the entire management and operational systems. That's what I used to do for a living, Mr. Capos. Thank you for doing it for the USPTO. And Mr. Lemon serves as Vice President of Legal Affairs at the National Retail Federation. Mr. Lemon oversees federal, legislative, and regulatory advocacy on a wide range of IP and commerce issues. Earlier in his career, Mr. Lemon spent nearly 7 years with the U.S. Senate Judiciary Committee, serving under Senator Mike Lee. Welcome, Mr. Lemon. Mr. Cohen, we'll start with you and go down the aisle, or down the desk.
Okay, thank you very much. Mr. Chairman, Ranking Member, and members of the subcommittee.
By the way, before I get started, I should say it's at the chairman's discretion to swear you in. I generally don't swear you into these committees, and a lot of that has to do with all of the feedback that we get back later on. I know you're going to be honest, and all the people watching, either here in the room or on C-SPAN, are going to take you to task if you go too far off strategy. So now you can start, Mr.
Thank you. I feel much better now. Thank you. Thank you for inviting me to testify on patent eligibility issues. I applaud the committee's efforts to look at other markets, such as China, in evaluating the need for para Needless to say, the opinions expressed here are my own. My point today is that the United States has created uncertainty in its rules on patent-eligible subject matter during a period where China has steadily broadened and clarified its laws. This divergence has been to China's distinct advantage. Since the Chinese patent law's passage in 1984, China has amended its patent law 4 times. Between revisions, it has used detailed guidelines, pilot programs, and local experiments to continuously adapt to new technologies and challenges. In other words, China has continuously used the patent law as a tool for technological catch-up and competitive advantage. In the USA, judicial decisions, which were just noted, have produced an eligibility test that is vague, unpredictable, and inconsistently applied since the period from 2010 to 2014. The Patent Office has tried to provide clarity with guidelines, but it cannot overcome judicial interpretations. Courts, the PTAB, and the USPTO reach inconsistent outcomes. Entire industries, particularly in such areas as diagnostics and software, face higher uncertainties, including risks of patent invalidation. These developments have had documented long-term impacts. We have been living through a natural experiment for the past dozen years since the Supreme Court narrowed eligibility. During this same period, China has expanded eligibility in emerging technologies through bright-line technical solution tests, producing a surge in filings and investment, both domestic and foreign. This divergence lets us compare outcomes under different legal regimes and shows that eligibility rules are not merely academic, they shape national competitiveness. How has China moved to expand eligibility? In 1992, it added pharmaceutical protection that had previously been excluded. Human diagnostic methods, which are statutorily ineligible, can be redrafted into allowable product claims. In 2019 and again in 2024, China updated its guidelines to broaden protection in software, AI, big data, and even stem cell research. Examiners are told to consider the claim as a whole and focus on the technical solution. This approach in general makes patenting more predictable. AI patent growth underscores these differences. In China, AI patent filings grew from roughly 59,000 in 2019 to nearly 189,000 in 2024, more than tripling in 5 years. By comparison, US patent filings during the same period were essentially flat, between 31,000 and 35,000 annually. During this same time, CNIPA, that is Chinese Patent Office, has also twice revised its examination guidelines to make clear that computer-executed information processing methods remain patent eligible and to emphasize the requirement of a technical solution. In the United States, AI patents remain vulnerable to unpredictable abstract idea challenges under Alice, although despite their low number, they do tend to have a higher citation value on the US side. Diagnostics during COVID provide a further cautionary tale. Since the Supreme Court's decision in Mayo, the Federal Circuit has held that virtually every diagnostic method claimed to be ineligible. Empirical analysis has concluded that in the 4 years following Mayo, venture capital investment in diagnostic technologies in the US was nearly $9.3 billion lower than it would have been otherwise. As another example, although American innovators filed many COVID-related diagnostic applications, eligibility uncertainty discouraged commercialization and private investment. The United States thus entered the recent pandemic with stronger support for vaccines than for diagnostics. Another point concerns retroactivity. In the US, patents obtained in good faith can later be invalidated under new judicial standards. In China, by contrast, the law presumes against retroactivity, while permitting retroactivity in narrow cases to enhance rights. This stability also encourages longer-term investments in key aspects. My lesson is not that we should copy China. Rather, we need to recognize how our competitors use their patent systems strategically, including to benefit their own industries and encourage investment. If our rules remain unclear, there's also the risk that investment and jobs will migrate from the USA to China or to other markets. I join Andre Iancu in urging Congress also to provide active oversight of how eligibility standards are implemented, not limited only to patenting, but also to the full range of commercial and security consequences. PERA restores clear statutory baselines, preserves exclusions for laws of nature and mental processes, and removes unnecessary unpredictability. Importantly, PERA does not weaken other grounds of invalidity. Patents may still be found to be not new, non-useful, obvious, enabled, not enabled, et cetera. PARA ensures that eligibility is restored to its limited threshold role. By passing a carefully worded PARA and by exercising ongoing congressional oversight, this committee will send a strong message that the U.S. intends to maintain a reliable, competitive, and predictable patent system, one that attracts investment, supports commercialization, and strengthens Americans' leadership in the global innovation economy. Thank you, and I look forward to your questions.
Thank you, Mr. Cohen. Mr. Ianco, before you get started, Senator Coons, would you like to make any comments before we move on with introductions?
Thank you very much, Chair Tillis. Let me just simply say more broadly that finding bipartisan agreement on patent reform is a critical undertaking for this subcommittee, for the committee as a whole. I'm grateful to continue on this journey with Senator Tillis, with whom we held a hearing on this exact subject, I think with 45 witnesses, now quite a few years ago. So thank you for your engagement, for your testimony today. Thank you to the chair and ranking of the subcommittee for your continued engagement, and let's work together to try and help clear the thicket of Section 101 jurisprudence.
Thank you, Senator Coons. Director Iancu.
Thank you, Chairman Tillis, Ranking Member Schiff, and members of the subcommittee. Thank you for another opportunity to discuss PARA and the urgent need to bring clarity to Section 101 of the Patent Code. I want to begin by commending Chairman Tillis and Senator Coons for their leadership in reintroducing PARA and staying with this issue over so many years, as well as Senators Blackburn and Hirono for co-sponsoring the bill, and this subcommittee for once again taking up the critically important task of modernizing, as Senator Tillis mentioned, one of the most fundamental provisions of our patent laws. After more than a decade of confusion and inconsistent court rulings, only Congress can resolve the uncertainty that threatens investment, innovation, and America's competitive edge. I want to focus most of my remarks on the critical and immediate need for Congress to act. The categories of patentable subject matter outlined in Section 101, any new and useful process, machine, manufacture, or composition of matter, were first listed in the Patent Act of 1793, as Senator Schiff mentioned, when Jefferson and Madison were writing law, and have remained largely unchanged for more than 230 years. Yet, the technologies that power today's economy were unimaginable back then. As a result, courts and agencies have struggled to map 18th century text onto 21st century innovation, resulting in a confusing, contradicting, and ultimately innovation-destroying patchwork of decisions and exclusions that Congress never enacted. Article 1, Section 8, Clause 8 of the Constitution grants Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So here is the crux of the problem. While patents are for the useful arts, courts have lost sight, in many cases, of what the useful arts include exactly. Are medical diagnostic tests to be included? How about artificial intelligence algorithms? How about advanced data processing that is so central to the information age? For many inventions in these and other areas, the answer is at best unclear, and at worst, some decisions exclude such critical technologies from the patent system altogether, such as medical diagnostics. This is untenable. I often say that patents are the currency of innovation. Patents incentivize innovation. They enable investment in that innovation, and they facilitate the transfer of that innovation to the market and the commerce surrounding it. But like any currency, the patent system depends on predictability and stability and cannot fluctuate on the whim of every new court or patent office decision. Some argue that the status quo works for them. Sure, chaos and uncertainty can benefit the few who are able to exploit it. But for the innovation economy at large, for the United States, chaos and uncertainty in the patent system is deadly. At scale, the uncertainty caused by the current state of the law on Section 101 is increasing legal and transaction costs and decreasing investment in new technologies, especially advanced technologies that require significant funds and time to develop. In turn, this is pushing innovation in such areas to other countries, diminishing our competitive edge, and opening the door, as Mr. Cohen so ably mentioned, to our fiercest competitors to take the lead in the critical technologies of the future. The world is at an inflection point for innovation. We are on the cusp of tremendous advances with remarkable new technologies such as artificial intelligence, biotechnology, quantum computing, and so much more. Yet the American innovation system has a hand tied behind its back with antiquated and unpredictable laws in this area. I urge Congress to clarify the law and unleash once again the great American innovative spirit. I commend the subcommittee once again for holding this hearing and continuing the debate towards modernizing Section 101. And thank you again for the opportunity to testify, and I look forward to your questions.
Thank you. Director Kapos.
Yes, good afternoon, Chairman Tillis, Ranking Member Schiff in absentia, and members of the Subcommittee on Intellectual Property. Thank you for the opportunity to testify today. I'm testifying solely on my own behalf. I also thank new USPTO Director Squires, who in his first week in office took a stand in favor of broad patent eligibility, not once, but twice. It's encouraging to see the administration and the USPTO recognizing that patent eligibility in the U.S. is broken and aligning with broad eligibility as the solution. The U.S. is living with doctrinal chaos in patent eligibility. Over the past decade plus, stakeholders have endured a roller coaster of shifting rules with decisions that contradict one another and defy planning. When innovators can't rely on predictable eligibility rules, investment pulls back, R&D stalls, and opportunities are lost. That is the opposite of what a patent system is supposed to do. The consequence, we are driving valuable innovation into trade secrecy. When eligibility is unpredictable, the rational response is don't disclose, keep it in the vault. This marks an alarming return to practices not seen since the Middle Ages, when our courts shut the door on entire categories of invention. We drive inventors back to a closed-door mentality that impedes knowledge sharing and advancement. This concern is not merely theoretical, it's happening now. Firms are opting to protect innovation via trade secrets rather than patents. WIPO statistics between 2013 and 2023 reveal that the number of patent applications filed in the USPTO when controlling for increasing applications from China has decreased 2.5%. So in the era of 101 doctrinal chaos, the PRC is propping up a U.S. patent system that Americans themselves are avoiding. The solution, PIRA, applies three simple principles. If an invention fits within statutory eligibility categories and has specific practical utility, it is eligible. Non-technological subject matter is expressly excluded, so no one can patent economic practices or wedding ceremonies. Eligibility becomes the gate, and the rigorous tests of sections 102, 103, and 112 do the rest. To be clear, restoring broad eligibility is not about allowing patents on ideas or bad patents or stifling basic research. It's about restoring coherence so that like inventions are treated alike, investors can underwrite risk, examiners can reach principled results when reviewing patent applications, and courts can adjudicate on stable footing. Under reform Section 101, every invention must still meet the stringent tests of novelty, non-obviousness, and full disclosure. Weak or overbroad patents would still be rejected, but for the right reasons, not through an unpredictable, distorted Section 101. A reformed Section 101 would also enable the USPTO to provide its examiners with stable, well-grounded examination guidance, which has proven impossible under the current framework. In the absence of clear law, the USPTO has resorted to shifting guidance, lacking lasting clarity, causing patents issued under one set of guidelines to become invalid under the next. With clear statutory foundation, the USPTO can provide consistent and legally compliant guidance for innovators and patent examiners. Now, I appreciate concerns about unintended consequences, such as frivolous patents or litigation abuse, but Congress fixed those problems with the AIA, and recent data shows that the USPTO is doing a good job preventing the issuance of weak patents. The greater risk lies in inaction. If we do nothing, we continue under a regime that virtually no one thinks is working. Even those who benefit from the current doctrinal chaos cannot defend it as clear and practicable. I'll end with a simple truth. Innovation that is never realized because our system failed to encourage it is an incalculable loss. We cannot afford such losses. PEER will prevent them and strengthen our innovation economy. Mr. Chairman, thank you again for the opportunity to share my thoughts.
Thank you. Mr. Lemon.
Chairman Tillis, Ranking Member Schiff, and members of the subcommittee, thank you for the opportunity to testify today. I'm here on behalf of the National Retail Federation and as co-chair of United for Patent Reform, which represents Main Street and other businesses of every kind: retailers, restaurants, banks, realtors, hotels, autos, and service providers that together employ more than 90 million Americans, 2/3 of the private workforce. Retailers have benefited enormously from innovation, and we value a strong patent system. Retailers routinely license and pay for valid patents. What we cannot sustain is a return to vague, abstract patents that create no new technology and serve only as the basis for litigation. With many bills, we have to speculate what the world would look like if the bill were to pass. In this case, we know what the world would look like because we've already seen it. Before the Supreme Court's Alice decision, patent trolls targeted retailers for ordinary, everyday practices. Companies were sued for having online shopping carts, emailing receipts, or putting maps on websites. None of these were real inventions. They were simply the routine ways of doing business adapted to new technology. Yet the cost of defending even one of these cases could be millions of dollars. And for many small and mid-sized retailers, that meant settling claims just to survive. This problem follows a familiar cycle. Each time a new technology emerges, opportunists rush to repackage ordinary practices as if they were inventions. First came the computer wave, where routine tasks were suddenly claimed as novel because they were, quote, done on a computer. Then came the internet wave, where those same practices were said to be inventive simply because they were, quote, done on the internet. The same thing happened with smartphones. Now we are seeing the beginnings of a fourth wave, patents that claim routine business functions that are, quote, done with AI. None of these waves created new technology. They created lawsuits. The Alice decision restored balance, allowing courts to throw out weak patents early and stopping years of wasteful litigation. The result was that retailers could adopt new technologies with confidence. Trolls brought fewer cases, and hundreds of bad patents were invalidated. Most importantly, real innovation did not suffer. Investments in e-commerce, apps, and digital tools has only grown since Alice. PARA would undo that progress. It would reverse Alice and 170 years of settled case law, bringing back the very patents that created chaos in the first place. Proponents of PARA argue that Alice created uncertainty, but the evidence shows otherwise. In reality, it is PARA that would create uncertainty by sweeping away decades of settled law. The impact would be felt across Main Street and ultimately by consumers. Before Alice, even a small business using an off-the-shelf reservation system or a simple online portal could be threatened with a patent lawsuit. After Alice, many of those cases disappeared. If PARA is enacted, they will return. And every dollar businesses spend fighting frivolous lawsuits is a dollar they cannot put toward lowering prices, hiring staff, or improving service. For consumers, PARA would act like a hidden tax, raising costs at a time when American families can least afford it. To be clear, Main Street still has a patent troll problem. More than half of all patent litigation this last year was from patent trolls. And with the recent weakening of the PTAB at the PTO and an increase in anonymous third-party litigation funding, that problem has been getting worse. Allow me to give you a recent example of the patents that caused problems for Main Street that Alice addressed. An LLC called Cascades Branding has a patent filed in 2007 that claims the following. A company logo appears on a device, the user taps the logo, the device identifies the user's location, and then it shows nearby stores for that brand on a map. For nearly 14 years, more than 30 Main Street businesses were sued for infringing this patent, including Lowe's, Chipotle, Target, Hallmark Cards, GameStop, Capital One, Best Buy, Marriott, and Aldi. Only recently did the Federal Circuit finally strike it down under Alice. That decision protected retailers and consumers from many more years of wasteful litigation. If PARA passes, patents like this one will come roaring back. On behalf of retailers, auto manufacturers, bankers, home builders, hotels, realtors, restaurants, startups, tech, and telecom, I urge the subcommittee to preserve the balance and fairness that Alice established and to reconsider moving legislation that would take us backward. Thank you, and I look forward to your questions.
Thank you, Mr. Lemon. I should have mentioned most of you all have been in committees that I've chaired before. I see Mr. Blaylock already getting his notes ready for the second panel, but I do a kind of a debate club format, so if any of you want to challenge an assertion or a comment that was made and in the opening statements, I'll give you an opportunity to do that. But since Senator Coons is here, I'm going to let him go ahead with his questions in case he needs to go back to another vote.
No, I'm fine. Thank you so much for your real and sustained partnership in this important area, Senator Tillis. Mr. Lemon just asserted that Alice did not create chaos. In fact, Alice produced certainty, protection from widespread lawsuits based on a weaker, improvidently granted patents, and predicted that if PARA were to be adopted, a whole new wave of patents would be improvidently granted, sort of AI applied to any typical business practice, and we would return to a period of widespread poor quality patents. As former PTO directors, Mr. Kapos, Mr. Yanko, any response, any comment? Is that how you view Alice? And is that why you think PARA would be valuable or invaluable? I'd just be interested in engaging with the argument he just made.
Yes, well, thank you for the question, Senator Coons. So a couple of...
If I may interrupt, Senator Coons, I am a tie-breaking vote on a committee matter, not on the floor, so I've got to go break a tie, and I will be back.
Fabulous.
If Senator Coons hasn't completely exhausted y'all by the time I've gotten back, then we'll stand in recess until I return. That's okay.
Got it. I'll exhaust them. Thank you.
Thank you for the question, Senator Coons. So, a couple of comments. First, none of us wants low-quality patents or inappropriate, untoward assertions of low-quality patents against retailers or anyone else. So we're all aligned around patent quality. PIRA would expressly exclude do-it-on-a-computer patent claims or do-it-on-AI patent claims. So in respect of that problem, which I would agree with Mr. Lemon was a problem in the past,
right.
PIRA would make absolutely no change in the law. Those claims were inappropriate, they are ineligible, and they will remain ineligible under PIRA.
Why?
Because PIRA includes language that expressly says adding rote computer or similar recitation, do it on a computer or do it on AI.
Does not create eligibility.
Right, does not confer eligibility. One other comment that I would make, relative to the case law has settled down and the case law is working fine. It's not working fine at all. And you don't have to go any further back than decisions from just the last couple of years in the U versus Apple case and then following it in Contour IP Holdings. Two cases, both about identical concepts, use of dual sensors in cameras in order to improve acuity of photography. The first one, you versus Apple, goes to one panel of the Federal Circuit that finds the claims to be abstract and ineligible. The second one, Contour Holdings, goes to a different panel of the Federal Circuit. Identical technology, right? It's indistinguishable. That second different panel finds the claims to be technological and perfectly eligible. So the law isn't settling down. It continues to be hopelessly confused.
In fact, if I understand correctly, a majority of the Federal Circuit has asked Congress to step in and clarify the jurisprudence in this area.
That's correct. In fact, every single judge on the Federal Circuit, all 12 of them as of 2021, if I remember right, decried and essentially begged Congress and or the Supreme Court to come in and clarify the law.
Pretty striking. Director Iancu.
Yes, look, I agree with what Director Kapos just mentioned. Let me just emphasize a particular point in response to Mr. Lemon's testimony. Mr. Lemon is primarily concerned with what he called vague patents that protect no new innovation. And certainly I agree that we don't want vague patents. We don't want patents that are not on new innovation and the like. No debate there, dispute there at all. We certainly don't want frivolous lawsuits on such, on patents that shouldn't have been granted and so on. But those are different questions from eligibility. It's a very important fundamental point to understand the distinction between eligibility and patentability. Just because some technology is eligible for patent does not mean that the patent office should grant a patent after all this examination is finished through all of the statutory requirements. If we see an application with vague claims, those should be rejected under Section 112 that specifically require claims to be claimed with particularity. If we see claims on something that's not new, those should be rejected under Section 102 that require novelty. Or even if they're obvious, they should be rejected under 103. Which require applications to be, or claims to be non-obvious. The problem we have had over the past several years is that courts have conflated these various statutory schemes. And I suspect that the variety of concerns and the patents that Mr. Lemon addresses as concerning to his members, if there's a problem with them, that could be addressed under the other sections of the law.
As I believe you explained to me many years ago, Director Iancu, 101 was meant to be a very coarse filter, and then each of those successive provisions of the Patent Act to be finer filters that say obviousness or particularity. And the current jurisprudence has conflated those and has reached back to 101 to invalidate patents that could or should have been invalidated under other tests.
That's correct. And because of this confusion, because we're applying concepts such as newness to Section 101 for eligibility, or concepts of vagueness, which should be Section 102, we were applying those to Section 101. We've lost track as a result of the real tests that have to be applied under the proper statutory framework. Look, examiners at the PTO and courts know how to do a novelty analysis under 102 or an obviousness analysis under 103. They know how to do a vagueness analysis under 112. Those, over many years, decades of precedent, that type of analysis is well established. What gets confusing is when you're supposed to do these types of analysis under 101 when there is no framework established for doing that analysis, and you don't need it because you have these other statutory schemes.
Thank you. Mr. Cohen, my sense is that you testified about how innovation isn't possible without strong patent protection and how uncertainty in the law of patent eligibility threatens innovation in a way that actually creates a national security threat. Help me understand, I missed your opening statement, I apologize, what you see as the national security threat and why that particularly is focused on or heightened by the lack of clarity on patent eligibility jurisprudence?
Yeah, well, these days people more and more are conflating trade issues or IP issues and national security issues, and sometimes a little bit too generously, but I think in this area there are genuine national security concerns. When we're talking about emerging technologies, there's a significant overlap with technologies where there are patent eligibility issues. And in recent years, we've see a great more of civil-military fusion, that is civil technologies that can be rapidly adopted to military applications. Drones, for example, that you can go play with them in a park, or they can be a tool for warfare. So the ability to obtain patents in technologies where it's fruitful to disclose, but it provides a leg up for the innovator, perhaps also to innovate in the security context as well, is critical to develop the revenue stream to support that kind of R&D activity. That's just another aspect of having an effective patent system that they have in emerging technologies. They can have a national security application.
Have you seen innovators, companies abandon patenting in the U.S. system and instead seeking patent protection in China or Japan or the EU?
Well, Adam Mossoff's article is probably the leading article on this. He's identified, I think, about 1,300 or so patents that were granted in the EU and or China that were denied in the U.S. on eligibility issues. And there is also other anecdotal information on specific patents. Whether we've seen migration of investment from the U.S. to China or migration of talent is a little bit harder because there really isn't that much research, frankly, on this topic. There's Adam's research. There's Robert Taylor, who interviewed investors in startup enterprises, and he was looking at the availability of patents, and he found it across technological sectors, software, diagnostics, and other areas. And there's also other survey data that's been out there on this topic.
Mr. Iancu, Mr. Kapos, you served as PTO directors in different administrations of the two parties, yet you seem to have reached the same conclusion, certainly with regards to supporting PARA. Should that surprise me at all? Can you explain how you came to the same conclusions, perhaps by different routes?
Well, one of the beautiful things about patent law, Senator Coons, is that it's nonpartisan or bipartisan. It's one of the last, probably one of the last areas.
Maybe the only area.
Maybe it's the only area. In reality, we guard that jealously. We are very proud of being in a system that is not driven by politics, by partisan politics. But look, we've both, I believe, seen the same thing. Another way to look at it is that I am primarily a litigator, and from a litigation perspective, I can see the problems that the unpredictability causes the parties. It causes unpredictability for both parties, for the patent owner and the accused infringer. When lawyers have a difficult time telling their clients with reasonable certainty what the outcome is more likely than not to be, that increases the likelihood of litigation. It lengthens the likely span of a particular lawsuit, makes it more difficult to reach a settlement or a resolution. Because, one side's lawyers is going to have a very different view than the other side's lawyers, given that for every Section 101 decision out there, there is an equal and opposite Section 101 decision, as Mr. Kapos example he gave in his testimony. So from a litigation perspective, and I'll defer to Director Kapos from a transactions perspective or other areas, but from a litigation perspective, for sure, I have definitely come to the belief for a long time now, it was one of the main reasons I wanted to go to the patent office some years ago, was to try to address this issue and try to bring some clarity.
Mr. Kapos, in the transaction perspective, is it your sense that this has driven down investment in several different frontier technology areas in the United States, the lack of certainty, the litigation risk, the inability to say, yes, if we invest more in this field, we'll be able to get a patent and we'll be able to defend it, and thus we'll be able to achieve a certain market progress?
Yeah, that's exactly right, Senator Coons. And I'll give you a few examples. So in my practice, which is very much transactional, so helping investment to come to great ideas, whether it's in an academic to small company context or large company context, what I hear and what I have to advise in connection with eligibility is if you can avoid the patent system, avoid it, because it's not predictable, it's not dependable. So I'll give you a couple of quick examples. Wealthy investors from North Carolina seeking advice on investing in a great company making retrofitting automobiles with crash avoidance systems based on patents. When I looked at them, I quickly assessed extremely vulnerable to Section 101. So my advice had to be invest in this company and make them grow if they've got great leadership, if they've got great trade secrets, if they've got network effects. But I cannot advise you to make an investment based on their patent position because it is very, very vulnerable. Result, no investment, company goes out of business. That's absolutely what happens. One other quick example in another field, in New York, where I normally live and work, meeting with venture investors and private equity funds. And in those rooms, right, they will move very quickly once they are told by lawyers that an invention is likely to be ineligible for patent protection or a patent is likely to be invalid. And again, as a quick vignette, I was taken aside by a managing director at a private equity fund after we had a long meeting about eligibility for patent protection. And he said, listen to me, Sonny, my job is simple. When I leave the office at the end of the day, I have to have more money for my investors than I had at the beginning of the day. And if you smart people can help me do that by virtue of a strong and effective and reliable patent system that you can tell me produces eligible inventions that can be patented, fine. He said, otherwise I'm going to invest in pork bellies. And these are guys who move billions of dollars. So you can imagine, right, those meetings are happening all over the country, and they are not good for this eligibility discussion.
That's a lot of pork bellies. Last question, if I might, or you just, Mr. Lemon, because I've given everyone else a chance. You may not agree with PARA, but are there other bills you think Congress could or should take up and pass that would help strengthen our IP system?
I appreciate the question, Senator. Retailers in Main Street, as I said, are very invested in the success of the patent system. And while we may disagree on some of the proposals that have come out of the subcommittee, we do think that there are areas where lots of work can be done. In the area of third-party litigation funding, we see a lot of significant concerns there among all our broad membership. We would love to see the committee talk more about that. We have issues on the retailer side with customer stays that sometimes are denied in cases where we think that they should be approved. And so we're interested in talking about proposals to help make sure that there's a presumption of a customer stay when the manufacturer steps in to take the case. So I think there are lots of areas where we can work together to improve the health of the system.
Thank you, and thank you to all the panel members. Thank you, Senator Childs.
Senator Coons, I want the record to reflect that this 65-year-old made it to the Capitol and back, cast 3 tie-breaking votes in less than 10 minutes.
You are, as ever, overperforming.
And I'm looking forward to getting a readout on the questions that Senator Coons offered. I was in a discussion about a month ago with someone who is very focused on trade policy and actually very supportive of the administration's current posture on trade policy. I have some reservations in some areas, generally okay with what he's doing. But what I found interesting about this discussion with this economist, I said, I don't he made the comment that, well, I'm not accounting for, I'm looking this purely through the lens of the aperture as a trade expert. Of course, I'm not taking into account geopolitical factors and other things that may influence, may require you to throttle back on one policy or another, because it's not just about a discrete transaction. I feel the same way here. I feel that some who may be opposed to what we're trying to do with PARA are not realizing that I'm not only trying to work on patent eligibility, but I'm also trying to counter geopolitical threats. And so that has to be a key driver for me. It can't just be about the atomic considerations within the retail industry. That's important to me, of course, and it's not lost on me how important the industry is nationally and in North Carolina, but I also have to account for future threats that could ultimately even affect the retail industry if we don't get it right, if we lose our innovation advantage. So Mr. Cohen, I want to start with you. Let's say that this just as a non-starter doesn't get done. The 800-pound gorilla is China. Tell me what the future looks like and what we stand to lose if we just allow ourselves to fall into second or third place as an innovation economy.
Well, this is the issue that keeps me up at night. And unfortunately, the data we have does not suggest that the current direction is going positively. I mean, the Australian Strategic Policy Institute did a study that showed that China was dominating in roughly 90% of all the critical technologies. ITIF here in Washington has also done a study of different sectors, which also showed Chinese dominance. China is also increasingly coming to a position where they can, they're not only a follower of other countries, but they plan on making their own policies in their own interests, which is to be expected. And in areas where there are critical technologies, which China owns, which we're well aware of, like in electrical vehicle batteries or in pharma, where China has become is an important outbound licensor. They've also taken positions that they're not going to share their technology. China is not going to replace the US. China is going to be its own model for the world as a dominant technological power. That may involve less sharing, at least with the developed world, and a greater focus on critical technologies. We also are in an era of decreased transparency with China. So the ability to gauge how well foreigners, particularly Americans, are being treated. I could say that after observing this for 40 years, I know less today than 5 or 10 years ago, because China aggressively curates its cases, and I can't tell you how Americans fare before the courts in China. I have my suspicions, but I really cannot tell you because the cases are not transparent. So this is a great unknown in many respects. The other and final point I'd like to make is that China believes in IP. Now, many people in the US do not, many people in Congress may not, but they view IP as of strategic importance and important to enhancing their own power and prestige and capacity to innovate and attracting talent and whatever else you can add on to that. And they've taken steps to aggressively improve their system in their own interests. And I think there's an assumption here that this is so difficult to protect IP in China. China has no IP system. Well, they have roughly 500,000 court cases each year on intellectual property, which is several multiples of the US docket. They have specialized trial courts in intellectual property and appellate courts, and they have 5-year plans on intellectual property. After all, they're a socialist economy. So they're trying to leverage that in their own interests of strategically advancing and becoming a technological superpower. And I think to get back to your question, if we're looking at 5 or 10 years out, unless we dramatically improve our capacity for oversight and evaluating China's capacity for technological improvement, it will be very difficult to see where we will land, but it will not be a good place.
I'm going to turn to Senator Schiff. I am going to ask some other questions. Senator Schiff, I actually had to leave, go break 3 ties, and come back. So, I'm going to be here for the duration, but I'll go ahead and let you ask questions, and I'll ask afterwards.
All right, thank you, Chairman. In 2024, USPTO issued guidance on patent eligibility to help examiners and stakeholders evaluate whether AI-related inventions are eligible. Late last month, Director John Squires issued an opinion signaling even stronger support for AI-related inventions, clearing the Section 101 threshold. Mr. Kapos, let me start with you. I'd be interested in your thoughts on what AI-related inventions you believe should be eligible for a patent, what AI-related inventions you think should not be eligible. Is there a risk that allowing every AI-related invention to be patented could stifle innovation, and how do we ensure that the Patent Office strikes the right balance?
Well, thank you, Senator Schiff, for the question. So first of all, I would tell you that I applaud the recent changes made to the USPTO's eligibility guidelines by Director Squires and I think also Deputy Director Coke Morgan Stewart before Director Squires got into his job. I think that they lend additional clarity and expansiveness to eligibility for AI-related inventions. I would echo some of the examples that you gave earlier, Senator Schiff, in terms of where the limit should be. Mathematical algorithms, mathematical formulas equals MC squared, pi, things like that, not eligible. They never were. They wouldn't be under PIRA. They shouldn't be, even if implemented or somehow related to AI. But practical applications of them, use in advancing computer technology, broadly stated, absolutely should be eligible. And the much more suited tests of sections 102, novelty, 103, obviousness, and 112, written description, are the tests that always did and should be returned to their role of doing the heavy lifting to determine what gets patented and what doesn't.
Well, thank you. Let me turn, if I can, to the diagnostic test issue. Ms. Cohen, you made a compelling argument regarding the lack of patentability and therefore the lack of investment. I'd be curious whether any of you want to share a counter argument. What is the case to be made for the lack of patentability? Is this just the courts getting it wrong? Is there a different balance that should be struck? What are the trade-offs here?
Happy to start with that, Senator Schiff, and it's a great question. So look, we all care about ourselves and our loved ones getting access to medical diagnostics. That is super important, and we all care about those diagnostics being appropriately priced, and we're all upset when they're not appropriately priced. So I think, broad agreement that pricing in diagnostics needs to be reasonable and fair. But pricing is a very different issue from patent eligibility. Patent eligibility is about whether the diagnostic exists in the first place, whether the cure is there to be priced at some price. Once the cure is there, once the patent system has done its job and broad eligibility has incented research and development and moving that through the FDA clinical approval process to make a diagnostic or drug available, fine, we should have very tough discussions about pricing, but we need to put them in totally different categories because the diagnostic that doesn't exist because the incentives weren't there might as well be priced at infinity.
Anyone have a different view?
No, but I don't. I suspect on the next panel you'll find at least one witness who does. But Senator, one point I want to add to what Director Kapos just said is the bottom line is currently de facto under the court rulings, various court rulings, there are no patents on diagnostic techniques in the United States. And one has to ask, who made that decision? If the United States decides not to protect by patent such a huge area of, an important area of technology, it seems to me that that needs to be subject to debate in this body and decision in a democratic way in this body. That is why, in my view, it is so important for Congress to return to legislating here, where it hasn't done any since 1793, to address issues just like this. My personal view, and all my testimony today is just my own personal capacity, is that diagnostics are critically important technology, and we want to incentivize innovation in that area, an investment in that area, to bring more and more such new techniques that cure patients, treat patients, and overall increase improve the human condition. That's my view. And for that, you need to have patent eligibility in that space. And again, that doesn't mean that you're going to grant patents to all of those applications. You still have to make sure that the application, the invention is new, non-obvious, precise enough, and so on. But at least from an eligibility point of view, I don't think Congress has ever said that the United States should exclude that area of technology.
Thank you, Chairman.
Director Ianco, you covered one matter in answer to Senator Schiff's question about why we should be legislating. I think some PARA relies on language that some have suggested is undefined or that should, I guess, left to others. I think there are two terms that I want you to specifically talk about, and that's the term substantially and practically. Why are those problematic?
Well,
why should it be argued that they're problematic?
Substantially and practically that appear in the bill you're asking about, right?
Yeah.
Well, so the question, so the concern folks express is that those are vague terms that will be subject to litigation, and they're new terms in PARA. And would have to be eventually decided by a court as to what they mean. If folks don't like those terms, then they should propose something else. Those terms appear in the bill with respect to business methods. You know, it says that the process that is substantially economic, financial, business, social, cultural, etc., should not be eligible. That is in section B1B of the bill. So that is the concern. To be frank, we have to see if that actually adds the uncertainty that folks are so concerned about, and if it does, I'm sure the courts would resolve it fairly quickly. What I would say is that the main approach of PARA, and I believe the correct approach, is to identify categories which on their own, or as the bill says, as such, are not covered by the Patent Act, are therefore not in the useful arts. And Senator Schiff mentioned a few of them in his opening remarks, such as pure mathematical formulas, as such, pure laws of nature, gravity, apple falls from the tree and hits Newton in the head by itself. You just can't get a patent on gravity as such. Same thing with pure financial transactions. But as soon as they are incorporated into a practical application that is technological, then that should become eligible. That's what we tried to say in 2019 with the patent eligibility guidelines. That is what PARA does as well. So whether or not we have the term substantially in there does not affect that particular issue. As long as we clearly define what pure categories on their own, as such, are out, and how they would come back in, under what combinations, to become practical, then I think the bill adds much clarity.
Thank you. Director Kapos?
Senator Tillis,
Are you going to add to that? I was going to ask you a question, too, if you'd like to add to that first.
Well, yeah,
ahead.
just in the spirit of the debate club, so just to...
Yeah, and Mr. Lemon, you'll probably want to pay attention to the question I'm going to have for Mr. Kapos.
Just to add, so in a patent system that accommodates all manner of technology, there are some things that are going to be matters of degree, right, not matters of kind. And the words substantially and practically accommodate that. They put in the hands of fact finders and adjudicators of law, judges, some amount of discretion to be able to exercise judgment. That's what those words are about. There's no way to have a patent system and a set of laws around a patent system that accommodates and leads to fair results across all of the issues that come up without having some requirement for judgment on degrees, right? So something is substantially in the business domain, yes, that is going to require some amount of judgment by judges at points, and practically about a business method or not is going to require some judgment to be applied by judges. But the other extreme, or there's two other extremes, one which is randomness that we're living with now, right, which we're all here because that's not very helpful. And the other one is rigid rules that result in bad decisions as often as they result in good decisions, and that's not a very fine alternative either. So we've always, to be practical and to be reasonable in our patent system, included some words like obviousness, right, that we live with in Section 103, that requires some interpretation. I don't think of that as a problem with the patent system. I think of it as a strength of our patent system.
I want to add, as somebody who works on the corporate side of patent issues, and you see multiple sides of the retail industry, I'm sure, can you help the subcommittee put the retail industry patent issues in a larger framework? And then, Mr. Lemon, you can raise your card.
Yeah, sure. Happy to try to do that. So look, first of all, Chairman Tillis, I would say I'm a big fan, like probably most others in this room, of the retail industry. When I was leading the patent office, I took many steps in order to help the retail industry, including in our implementation of the America Invents Act. And it's a great industry, and we all want retailers to succeed. The issue and the perspective in my mind, and I believe that Mr. Lemon before mentioned some of the priorities of the NRF. I took a look at them also. As an example, the NRF's website lists top priorities, including tax provisions, trade strategy, tariffs, swipe fees, and organized retail crime. It doesn't mention nuisance patent litigation as a top priority. It doesn't even mention anything about patents as a top priority. In fact, it doesn't mention patent litigation at all as any priority. So I'm sure there are some nuisance suits, but they're not mentioned as a priority at any level. So looking at that, I took a look then at the SEC filings, the 10Ks, of the top 20 and the bottom 10% of the retail industry. And the 10Ks, of course, are public documents that require all material issues to be disclosed. There are dozens of them that are in these 10Ks. I couldn't find any of them, any of these companies that list nuisance patent litigation as a material risk factor. Slip and fall incidents, all these other ones that are mentioned here, retail fraud, et cetera, are mentioned. Nothing about nuisance patent litigation. In fact, only a very few of them mention patent disputes at all, some of them on the offensive side, companies that are trying to assert their patents. So I come away from that feeling like objectively, if you put this all in perspective, right, the retail companies themselves, the large ones and the small ones, are not listing nuisance patent litigation or any patent litigation as a major threat or a material issue for their business. So sure, we all would like to see less nuisance litigation of all kinds, slip and fall suits, employment suits, et cetera. But it just does not show up on an objective basis, just looking at the 10Ks and the statements made in websites as a material issue.
Mr. Lemon, I'm happy to have you respond, but I also want to make sure that you know that I have been pushing on third-party litigation funding, and at a minimum, I mean, this has become an industry that's highly disruptive. Sovereign wealth funds are investing in the U.S. and $2 billion, I don't know if you follow Camp Lejeune Toxics alone, $2 billion in third-party litigation funding. All I'm asking for is that they win, they at least pay ordinary income like the victims have to. But if you got ideas on other things that I can do to bring these folks to the table, that there's a need for some of this litigation, but now it's just become another investment option for people who couldn't care about the victims. So know that we're on the same page there, but you can go back to Mr. Capos's comments if you wish.
Well, I appreciate that we're on the same page on that. I think retailers do care about patent issues. I mean, that's why I'm here. I'm here at the behest of my members. So retailers many are large, complicated organizations that have lots of issues that they care about. And patents is one of them. I think part of what the breakdown is in where we're coming at this issue, we all agree, and I was happy to hear the other witnesses while you were both absent, they recognize that they don't want low-quality nuisance patents either. So that the goal is not to increase low-quality nuisance patents or nuisance lawsuits. From the retailer perspective, on the practical impact side, we look at the language of the bill, and I will tell you that I have not spoken to a single company in any of the sectors represented by UFPR, which is the majority of the US economy, that agrees with the interpretation that this will keep business method patents out. We expect the language of the bill to allow business method patents back in, and these are the exact ones that we get sued on. Now, the bill does provide specific exclusion for rote language, but what happens when you craft it in a way that doesn't use rote language and instead just applies technical jargon around the process they're describing, the non-inventive process, and they put technical language around it? That's what Alice said. You cannot put technical jargon around an abstract idea and make it patentable, patent eligible. Now, there's been a lot of discussion today also about the other sections of the Patent Act, saying that they will do the heavy lifting to prevent things from becoming patentable just because they're ineligible. What I'm saying is that wasn't the case before American Invents Act and Alice. Those sections were not doing the heavy lifting necessary to keep business method patents out. So our members were being sued on an innumerable number of these patents. And the other sections of the Patent Act did not do the work to keep them from getting patentable. So however you want to look at the entire act as needing some sort of reforming just this piece and hoping that the other sections somehow magically start to work better than they've worked in the past is not, on the practical side, going to be a good look for the most of the economy of the US. And the last piece that I'll say, thank you for giving me the time, is on the competing with China piece. From our perspective, PARA will not move us forward to competing with China the way that we're hoping. Because, one, when we relax standards for eligibility, which is what this bill would do, we are relaxing those standards for Chinese companies too. They participate. In fact, most of the patents granted by the Patent Office are to foreign entities. So we will be handing the keys to foreign Chinese companies to get lower quality patents that they can come and sue our members. And so we will be sending money to Chinese companies who will be getting these patents that we're hoping Americans will start to innovate more, but there's nothing to prevent Chinese companies from coming and taking advantage of that.
Mr. Cohen, do you have any comments since China was invoked?
Yeah, China's invoked, and I always wake up. I think the logic of Mr. Lemon's position is that we shouldn't have patents at all, because that way there won't be anything for Chinese to assert or others to assert. Or at least that's what it could easily be reduced to. We have to provide incentives for innovation in order to compete not only with China, but with other countries throughout the world. The reality is that other countries manage this issue without the same kind of disruptions and fear that have been invoked already. Europe has a different test, but it hasn't encountered the same problems. And the Chinese test is really pretty straightforward and simple in terms of a technical solution to a technical problem with a technical effect, and that the issues involving mental processes or laws of nature are somehow integrated into that decision. And then that's it. So it's not really an area that's of active debate for litigation. China in the U.S. is not a major litigant. I don't think we've seen the huge amount of litigation that some have feared, although China has been increasing its patent portfolio. And I think the proper counter to that is that we need to increase our patent portfolio in competitive technologies.
Okay. I'm going to go ahead so we can move to the next panel. But Mr. Lemon, have you reviewed the 2025 version of the paradraft? Where I think, if you have, what I'd prefer to do is, instead of extending this so we can get to the next panel, we have added some language that I think addresses some of your concerns. But if you have and you still have concerns, this is an iterative process. I've made it very clear that I intend to get something done, and I believe that we're on a path to getting to a markup. I want to sincerely address the concerns of everyone who worry about passage of this bill. But I think on the whole, it's balanced and needed, and I'm going to work hard to get it done. But I want every single one of you, regardless of where you are on the issue, to make sure you're talking with our office, and we're doing our very best to be accessible and address your concerns. Thank you all. We're going to transition to the next panel. Welcome to all the witnesses. Mr. Blaylock, I know that you know about my debate format, and I know you were taking copious notes during the opening statements and the entirety of it. And Ms. Peshin, I saw you also back there taking notes, so I'm looking forward to this panel getting started. Let me introduce Richard Blaylock. Mr. Blaylock serves as partner at Pillsbury, Winthrop, Shaw and Pittman LLP. Mr. Blaylock practices corporate and IP law for emerging and established life sciences companies in connection with financing, merger and acquisitions, licensing, collaboration, and partnering arrangements and IP counseling, as well as patent, license, trademark, trade secrets, and unfair competition disputes. Mr. Kaltreiter, did I get that name right? Thank you. Mr. Kaltreiter serves as the Chief IP Counsel at Dana-Farber Cancer Institute. Mr. Kaltreiter advises on the complexities of a global patent landscape, including U.S. and foreign procurement, litigation, and licensing matters. Prior to joining Dana-Farber, he served as Vice President and General Patent Counsel for Eli Lilly and Company before retiring after 34 years of service. Ms. Peshin, did I get your name right? Serves as the President and CEO for the Alliance for Aging Research. Since 2012, Ms. Peshin has led the Alliance team in efforts to substantially increase federal investment in Alzheimer's disease and aging research, to develop Talk Nerdy, a research engagement network for more than 200 older patients, family givers, and researchers to advocate for equitable Medicare affordability and access. I love the Talk Nerdy initiative, by the way. Let's see, Mr. Salzberg serves as Vice President and Global Head of IP Affairs at Novartis. A seasoned attorney with over 25 years of experience, Mr. Salzberg has testified before committees of both chambers in Congress, has appeared before the World Intellectual Property Organization, or WIPO, and the World Health Organization and the United Nations. He currently also serves as the president of the Federal Circuit Bar Association. Thank you all for being here. Mr. Blaylock, we'll start with you.
Thank you, Chair Tillis, Ranking Member Schiff, and other members of the subcommittee. Thank you for the opportunity to address the topic of patent subject matter eligibility today. I'll focus my remarks on the consequences of the proposed Patent Eligibility Restoration Act, or PARA, for the life sciences. The U.S. is and has been at the forefront of a revolution in personalized medicine. This has been made possible due to the sequencing of the human genome, the drastically increased affordability of genetic sequencing technology, and most importantly, the robust and ongoing exploration of the human genome. Researchers across the U.S. and indeed around the world have collaborated to identify variants within the genome that correlate with certain disease states, increased lifetime risk of disease, and suitability for certain drug therapies. These variants, or biomarkers, are clinically measurable facts about a patient that can inform both a patient and the patient's doctor about health and treatment. New biomarkers are being discerned on a daily basis, and the current law enables this important work. Regrettably, PARA would slam the door shut on access to new biomarkers. PARA would allow the privatization of medical knowledge through the patenting of biomarkers and preemption of all methods of their detection, including any research or clinical use of them. Under current law, as articulated in a series of 9-0 Supreme Court decisions, even on the Supreme Court, patent law is bipartisan, correlations between biomarkers and clinically important patent information, natural laws in the parlance of Supreme Court jurisprudence, is not eligible for patenting. Thus, the discovery of basic facts about human biology are not patentable. Nor can they be made patentable by simply combining those facts with existing conventional technology for their detection. The state of the law is a consequence of the Supreme Court grappling over the decades with very real concerns about the negative consequences of allowing the preemption of basic natural laws through patenting. This state of affairs allows the entire research and clinical community to make use of this knowledge in advancing medicine and individual patient care, because no one can use a patent to bar or impair access to this information. It is also critical to recognize that the current law does not prevent the patenting of new and innovative technologies for detecting biomarkers. You heard former Director Iancu announce that the patents on diagnostic technologies in the U.S. are not allowed. That is just categorically false. Many companies continue to advance the field through the development of new diagnostic platforms that improve the range and efficiency of techniques for diagnostic testing in its myriad forms, and they are getting patents on these. Senator Tillis, you mentioned that Director Squires had recently signed a new patent relating to diagnostics. Perfectly fine. That is a patent that is directed to novel antibodies. There is nothing about the current law that prevents the patenting of new antibodies that may be useful in diagnostics. And so the current law does not impair the advancement of the diagnostic field. And additionally, many new point-of-care diagnostic testing platforms are being developed and patented and brought to market. And these point-of-care platforms are advancing patient care by allowing physicians to receive answers to lab tests in minutes within the clinic without needing to wait days by sending samples to outside labs. Current law retains the valuable patent incentives to develop new and better ways to conduct laboratory tests and new tools for doing so. It simply does not allow any one person to claim ownership of basic medical knowledge in the form of the results of those tests. PARA would change that to the detriment of patients as well as a functioning diagnostics industry. There would be a proliferation of patents covering the many biomarkers of interest necessary to standard of care genetic testing for many conditions. Any of scores of new patentees, whether in the US or in China, could stand in the way of a clinician's effort to conduct a comprehensive analysis of a patient's genetic information. Permission would need to be secured from all of them, none of whom, under US law, would be obliged to grant such permission. PARA would return the US to a time when patients had to fight for affordable access to most scientifically up-to-date testing. Also, I want to note that PARA would not bring clarity, unfortunately, to the law. And I've mentioned other issues in my written testimony, but I'll simply note that PARA identifies a closed set of exclusions to patent subject matter eligibility. But Sadly, these are just Potemkin exclusions as they relate to human genes and natural materials, because these exclusions are subject to additional conditions in the statutory language which hollow out the exclusions to the point that there is little or nothing they actually exclude. You could omit those exclusions from PARA, and PARA would have the exact same effect. They are window dressing, sadly, but nothing more. See, my time is up, so I wish to say thank you for the opportunity to speak with you today. On this very important topic, look forward to the opportunity to rebut some of the other comments I heard earlier today.
And we'll
Thank you.
certainly submit your formal statement to the record. I did want to point out, I talked about Mr. Squires picking 2 patents to sign. I think that was to send a signal that those particular ones are now eligible. But I get the points that you made in your argument, but I think that's the point he was trying to make by the ceremonial signing. Mr. Cartwrighter.
Thank you, Chairman Tillis, Ranking Member Schiff, and members of the committee for the opportunity to present this testimony. I currently serve as Vice President and Chief Intellectual Property Counsel at the Dana-Farber Cancer Institute. I provided written testimony on patent eligibility to this subcommittee in June of 2019. Unfortunately, little progress has been made on the eligibility crisis. Please make no mistake, this is a crisis. The fact that innovators are adapting into the current legal framework and managing as best they can does not mean the crisis is solved. Opposition to the current law of eligibility is often justified as an issue of patient access. I wholeheartedly agree that patient access is critical. It's why innovators and caregivers at Dana-Farber do what we do. Our mission is to help patients with innovative therapies and scientific discoveries. The ultimate barrier to patient access, however, is a medicine or a diagnostic never being discovered, developed, or commercialized. Patients who never receive the diagnostic testing that enables earlier detection or the treatment that could have saved their life are unquestionably denied access. Denying patient access to discoveries never developed and commercialized due to poor IP policy is the real travesty. Lives are impacted and likely lost. That makes it all the more important to act urgently. I noted in my 2019 testimony, patients are waiting. They are still waiting. Dana-Farber does not undertake the development necessary to commercialize its research. For innovation to reach patients broadly, we work with commercial partners who make the substantial investment to secure the necessary regulatory approvals. The uncertainty of strong patent protection puts this investment in these critical partnerships with the private sector at risk. Unfortunately, the crisis now threatens innovative treatment options. The Regenex Bio versus Serepta Therapeutics case was heard yesterday by the Federal Circuit. The claims at issue in Serepta are directed to engineered host cells useful for gene therapy. This isn't the forum to litigate the merits of the case under current law, but this is the forum to step back and ask the policy questions. Should there be any doubt that the subject matter, an engineered cell combining known portions of nucleic acid useful to deliver a gene to patients to provide hope for a cure, is not patent eligible? Without a question, it should be. These gene-based treatment modalities are also not the only treatments at risk. Claims to man-made peptides called degrons have been rejected. Claims directed to antisense oligonucleotides have been rejected. Claims directed to RNA-based therapies have been rejected. While the legal landscape for treatment-related patents is not yet as dire as the medical diagnostics, defending against patent eligibility challenges creates a strong headwind against innovation and remains only one adverse court decision away from being catastrophic for patients. But what about patient access? I'm certain that patents and PARA in particular are not a barrier to patient access. The current standard of care and testing of genes linked to hereditary cancers will not change or be impacted by PARA. Plainly stated, you cannot patent what is already known and standard of care. As I noted, opponents of PARA argue that the current law prevents patents of unprecedented scope and ensures that the fundamental building blocks cannot be monopolized. Respectfully, the argument is misplaced. A patent holder can no more control all preclinical and clinical research on a human gene after this bill passes than they could today. In my opinion, PARA's opponents are really against is the loss of an opportunity for a quick kill in litigation. The cost required to litigate a patent is a real issue, but furthering the eligibility crisis because it may be faster to kill certain patents that lack merit is throwing the baby out with the bathwater. It is obviously not good IP policy to undermine life-changing innovation so that so-called low-quality patents are more easily invalidated. The legislative history of the Patent Act makes clear that Congress intended to broadly cast patent eligibility. This was for good reason. Today's inventions were unimaginable. A more restrictive eligibility criteria risks the very problem that we confront today through judicial fiat. Entire promising fields of research are threatened by misguided eligibility standards. Congress was correct that eligibility should be broadly cast. Remarkably, the Federal Circuit judges in Athena Diagnostic noted that the Supreme Court ignored or disregarded Congress's wishes. PARA corrects this disregard by defining eligibility broadly and letting the substantive sections of the patent statute 102, 103, and 112 do the heavy work of sorting meritorious inventions from unpatentable subject matter. In closing, I commend you and your staff for your continued efforts on this legislation, and I welcome the opportunity to assist any way I can. Thank you.
Ms. Peshin.
Chairman Tillis, Ranking Member Schiff, and members of the subcommittee, thank you for the opportunity to testify today. My name is Sue Peshin, and I serve as President and CEO of the Alliance for Aging Research. The mission of the Alliance is simple. We are dedicated to changing the narrative to achieve healthy aging and fair access to care. Personally, I am a family caregiver to my mom, who is 84 and lives with kidney disease, severe arthritis, and dementia. Today's hearing is not an abstract policy debate for older adult patients and family caregivers like me. This is about lives, choices, and hope. All of us rely on medical breakthroughs that begin with discovery, but for over a decade, our patent system has struck down thousands of patents and failed to protect some of the most transformative innovations in diagnostics, not because they weren't new or useful, but because of confusing eligibility standards that made the system inconsistent and chaotic. The root cause of this major shift was a series of Supreme Court cases. Several witnesses here today are experts in the details of these. I'm not one of them. But I do bring 5 observations to share as a patient advocate that I hope that you'll consider. The first is Federal Circuit judges themselves have asked Congress to resolve the confusion resulting from the Supreme Court's decisions. In the case of Ariosa v. Sequinam, Judge Lynn stated, quote, "But for the sweeping language in the Supreme Court's Mayo opinion, I see no reason in policy or statute why this breakthrough invention should be deemed patent ineligible. In my view, the breadth of the second step of the Mayo test is such that it's difficult to imagine any diagnostic claim that could survive. If the law is to be changed, and I believe it should be, that change must come from Congress," end quote. So it's up to you to fix this. Second, the 2012 Mayo decision and others that followed made it nearly impossible to patent diagnostic tests that rely on biological markers, the very tests that tell us who has cancer, who will benefit from a therapy, or who might suffer an adverse reaction. These aren't just ideas on the blackboard. These are real tools developed by researchers, tested in trials, and used by families to make decisions that affect their future. Others here might argue that new biomarkers could be detected on already existing assays. What does that matter? Without patent protection, many of these tests are never developed, or they sit on a shelf because no one will fund them. Third, when innovators can't get patents, they often withhold discoveries as trade secrets, especially in diagnostics. That hurts scientific transparency and it slows progress. During the patent application process, companies publicly disclose their invention, which allows for future innovation. Trade secrets stay secret. Fourth, there's no doubt that there have been bad actors, but we can't fix litigation abuse by breaking innovation incentives. Researchers at numerous top American universities have left behind novel diagnostics for lupus, Alzheimer's, major depressive disorders, cancers, including metastatic cancers, schizophrenia, and rare pediatric disorders, after the USPTO rejected or weakened their patents because of the eligibility rules in Mayo. And that's heartbreaking. Fifth and last, I'm personally encouraged by the fact that the former directors of the U.S. Patent and Trademark Offices under both Presidents Trump and Obama are testifying in favor of this bill. and that the bill has bipartisan support in both chambers of Congress and among many former Federal Circuit judges. There's shared agreement that something is wrong and shared commitment to fix it. That doesn't happen often these days, and patients don't have time to wait. The Alliance for Aging Research is honored to strongly support the Patent Eligibility Restoration Act of 2025, or PERA. PERA would restore the balance. It doesn't let companies patent nature. It allows them to patent inventions that apply human insight to nature, to turn discoveries into action, into treatments, and into better outcomes for patients. When patent law works, patients benefit. We get earlier diagnoses, more effective treatments, and more personalized care. When it doesn't, we lose time, we lose tools, and we lose lives. Thank you, and I look forward to your questions.
Thank you, Mr. Salzberg.
Thank you. Chairman Tillis, Ranking Member Schiff, and members of the subcommittee, on behalf of Novartis, a leading innovative medicines company and a pioneer in cell and gene therapies and other advanced technologies, thank you very much for the opportunity to testify today in support of PERA, a bill that restores much-needed clarity and strength to the U.S. patent system. In the 6 years since I last testified before this subcommittee on this issue, patent eligibility law in America has gone from bad to worse. While we worried then about the law's lack of clarity and the many useful inventions that had been shut out of the patent system on account of it, our main concern was for the future. The Supreme Court, we feared, had created a judicial snowball, a test so ill-defined it would lead the lower courts to continually expand the scope of what cannot be patented well beyond what the Supreme Court intended in Mayo, Myriad, and Alice, and into the core fields that were defining the future of medicine. Our predictions, unfortunately, were only too accurate. Just yesterday, the Federal Circuit heard oral argument in a case with potentially dire consequences for biotechnology. The case, the one that Mr. Kaltreiter just mentioned, REGENXBIO versus Serepta, concerns patents on genetically engineered host cells that produce the type of viral vectors in gene therapy to deliver genes to patients, missing genes to patients, treating and potentially curing a range of diseases. The engineered cells in the case are created in a laboratory and include recombinant DNA sequences made up of genes spliced together from at least two completely different species of organism. Even the accused infringer in the case agreed that cells like this do not occur in nature, and yet the district court found them to be patent ineligible products of nature because they are built from components of nature. The decision is as legally wrong as it is illogical. The compositions of matter have been statutorily patent eligible since 1793. In 1980, in a landmark decision called Chakrabarty, the Supreme Court held that organisms produced by genetic engineering in precisely this way are non-natural compositions of matter that plainly qualify as patentable subject matter. It later reaffirmed this precedent in Myriad when it distinguished the isolated human genes it found ineligible there from applications and modifications of genes which it held to be eligible. And yet the district court in REGENXBIO still decided what it did. The implications should worry everyone. Chakrabarty's confirmation half a century ago that genetically engineered organisms are patent eligible is widely credited with having spawned the US biotech industry, giving rise to everything from gene sequencing tools to monoclonal antibodies to today's gene therapies. If REGENXBIO stands, it threatens not only the future of those fields, but countless inventions in almost every field because, as the Supreme Court has reminded us many times, all inventions at some level embody, use, rest upon, or apply laws or elements of nature. Even if the Federal Circuit reverses the decision, it cannot reverse the increased uncertainty the case has unleashed. If one court can so easily brush aside half a century of precedent, innovators know that it's only a matter of time before another does the same with perhaps a different outcome next time on appeal. That is the stark reality of a body of law that the Federal Circuit itself has called panel dependent, one it has said it is at a loss as to how to consistently apply. It is also what has already happened with patents on biotechnological methods. Mayo's bar on certain diagnostic methods now bars patents on basically all diagnostics. Even method of treatment inventions, which the Supreme Court in Mayo said are eligible, have since been questioned. And to make things worse, eligibility today often comes down not to what invention a patent covers, but to what words are used. Methods of detecting, optimizing, and determining are out, but methods of preparing, operating, or regulating for basically the same purpose just might be eligible. Patent eligibility law should not be this complicated. It's simply a matter of deciding what types of innovations the U.S. wants to promote and what types it does not. The Constitution entrusts those decisions exclusively to Congress, and with the Supreme Court having now denied at least 64 cert petitions seeking further clarity since Mayo, it's clear things will not improve unless Congress acts. Innovators in gene-based medicine badly need that intervention. As a pioneer in the field, we're counting on the US and its patent system to support our efforts to develop the next wave of these technologies here. Earlier this year, in fact, we announced plans to invest an additional $23 billion to expand and enhance our longstanding U.S. R&D and manufacturing infrastructure. With commitments of this scope, we need to know that the patents that enable us to start our work at the frontiers of medicine will still be eligible if and when we succeed in converting the bold leads they encompass into tomorrow's cures. PARA provides that reassurance. By defining what is eligible and what's not, PARA reins in the snowball that eligibility law has become and restores the predictability that cases like Regenx's Bio take away. While the bill still sets America's patent laws behind China's, Europe's, and Japan's, all of which allow patents even on isolated human genes without any of the ill effects that critics claim would happen here, by codifying Myriad, PARA at least makes clear to American innovators that if they modify or apply genes, the foundations of biotechnology, their efforts will not go unrewarded. Thanks again for the opportunity to testify. I look forward to your questions.
Thank you, Mr. Salzberg. I'm going to turn to Senator Hirono. She was a bit surprised that I asked her if she wanted to go first, but the reason I want to give her every opportunity to go first is she is one of the most consistent attendees in these hearings in the years that I've been here, and I want it to be a positive experience for her. So, Senator Hirono.
You know, as a psychology major, I know what positive reinforcement it involves. It's like a Pavlov's dog, you know, you say, here, you get to go first, and the behavior continues. So it's very smart of you. And then I thank my colleague for letting me go first. But I do thank you, Mr. Chairman, and our ranking member Schiff for this hearing, which might teach us a thing or two. So this is like a normal hearing. It's nice. And of course, I want to thank you and Senator Coons for being a leader on making the kinds of appropriate changes to eligibility reform. I do acknowledge that the Supreme Court's decision in Mayo and Alice that took place over 10 years ago created a lot of confusion and upended precedent, and as I said, introduced a great uncertainty into our patent system. And the appealing to the Supreme Court to remedy this situation have fallen on deaf ears to the court that actually engaged in writing legislation when they did their decisions that created this chaos, in my opinion. So here we are with a bill that would create some level of certainty into a system that I think is really important, especially in the medical research area. And I do acknowledge how important innovations in diagnostics are critical to millions of people in our country. And so this is a bill that's gone through some iterations. And I think the biggest change in this year's bill, I think, is that we make it clear that you can't patent an individual gene. And that is to respond to some of the concerns that were raised in earlier versions of this bill. But, you know, I'm certainly open to other discussions and changes about potential research relating to genes. So as we go forward, I think not only is it important that we provide this level of clarity that the Supreme Court has not seen fit to address in over 10 years, but I think we should be open to any further amendments that will make the system work a lot better, and at the same time create an environment where we really will continue, our country will continue to be a leader of medical research. Basically, this regimes, I call it a regime, their cuts to NIH funding I really raises concerns about our continuing leadership in medical research, and certainly these kinds of confusion in our patent system do not help, and that's why we can do something about it with this legislation. For Mr. Kalrider, there were concerns raised with the, as I mentioned, the previous version of this legislation relating to the eligibility for human genes to be patented, and whether those genes could have actually been patented was a different question. But this version of PARA specifically provides that human genes isolated as such should not be eligible. So in your view, does this limitation on patent eligibility strike the right balance between not allowing the patenting of human genes while still
Thank you for the question. The short answer is yes, it does. The patentability of genes is an interesting question because I think it actually is, you can deal with it as an eligibility issue, which the bill does and says they're not eligible. They're also not patentable at this point in the sense the genome's been sequenced and the prospect of getting a patent on a gene at this point really is resolved, whether it's in eligibility or whether it's in 102, it's not available any longer. So it is an issue that is, in my view, resolved and it strikes the right balance. No, that's not what I'm saying. I'm a little bit neutral on the language because but if it makes people who oppose the bill more comfortable to have that in the bill, I'm fine with it being in the bill. I think you get the same result whether it's there or not, but if it helps advance the legislation, I agree with it.
We are fine with the limitation. We think it basically codifies Myriad's distinction between isolated genes and modifications and applications of genes, which enables us to do the work we need to do to invent tomorrow's cures.
I agree.
Regrettably, I would delete the entire draft because I genuinely believe that the current law is superior to. That said, if over time, if PARA is advancing and if your office or Senator Tillis's office is open to dialogue on the language, I'm willing to address it. This is not what I would call my improvement, but since Senator Hirona was just asking about genes, let me speak to this one point. The exclusion here is only for human genes, and while it's true the human genome is, has been sequenced, the human health is also related to the genomes of all the myriad pathogens that we encounter. All of those, including for SARS coronavirus 2, its genes would also have been patentable. SARS coronavirus 3, which I hope we don't encounter, but if it does come, its genes, could be patented, and that could control, the response to a next pandemic. Similarly, as much as it says an unmodified human gene, as it exists in the human body, is excluded, the next page says, oh, by the way, don't consider it unmodified, which means the exclusion has no effect if that human gene is purified, enriched, otherwise altered by human activity, or even if it isn't, even if it's exactly unmodified as it exists in the body, as long as you use it in some useful practice. Well, that's not an exclusion at all. I would defy someone to come up with anything other than claiming that my walking around with the gene functioning in my body is is an infringement. I cannot think of a way to write a claim that would be excluded with this
Mr.
language.
Calwriter, if I might just ask you, Mr. Blaylock is essentially saying PARA imposed no limits whatsoever on the patenting of genes. Would you agree with that critique? And how would you explain the difference between his characterization and yours in your support of this bill?
Well, let me go to the question on genes of pathogens, because I think it's a good question to ask. In my view, a gene to a pathogen may be strictly eligible, but I don't see how it's patentable. Even under Section 101, a gene must have a substantial and practical use. And N. Ray Fisher disregarded many of the uses in research that you would, or found that many of the uses in research that might be a pathogen's gene might be useful for, do not give it utility. So I don't see how it's useful to begin with. In terms of human genes, I think you have to read that clause really, it should be drafted narrowly. Who would imagine where we would be with gene therapy today, cellular therapy today, if you aren't very, very careful on how that language is proposed? In fact, you didn't ask me, but what I would change is probably delete those exceptions as being unnecessary, because I think that you run the risk that we don't know where the science is going to go. And will you preempt the future by virtue of having language that today looks reasonable and something workable and something that many people in the life sciences can compromise to, but in the future is it going to have unintended consequences because we simply do not know how science is going to develop.
I understand your concerns. A core concern of ours is getting this passed. If you'll forgive my practicality. Ms. Peshin, if you had one change you would suggest or one issue you wanted to raise before my time is up, I'd welcome it.
Thank you. I support keeping this in, and the reason why is because Mr. Blaylock continues to say, both verbally and in his materials, it doesn't include this, but it includes it. And it's sort of mirroring the confusion that have been created by the Supreme Court cases from my perspective as a patient advocate. And I think it does create kind of public confusion around it. So I think putting it in definitively, that it does not do this, is important.
In conversations with colleagues in the last Congress, it was an issue. And part of the point of including this language was to resolve and clarify this concern and to have patient advocates, researchers, folks who represent world-class institutions saying this matters and we can live with it helps a great deal. Thank you all for your testimony. Thank you, Senator Jones.
Thank you, and I apologize to make you repeat yourselves, but...
No, it was great. A Republican has yet to ask questions.
Mr. Calwriter, what do you say to Americans who are worried that allowing companies to patent medical diagnostic tests would make those tests unaffordable, as we saw with BRCA 1 and 2 in Myriad at $4,000 a test? And Mr. Blaylock, love to hear your contrary view, counterpoint if we could.
Certainly patient access is important and price is important, and those issues are really different issues than patent eligibility. The bracket patents were invalid. They were invalid under 112 and 102. If things have gone its natural course, the law would have developed even more under 102 and 112 to yield the very same outcome on those patents. The issue is an eligibility question, which is a different question than patentability. That subject matter, in my opinion, should have been eligible, but the patents should have been struck down for other reasons because they were drafted too broadly. The definition of isolated made the patent read on and lack novelty. The claims were invalid under 112 and overbreath, and that's a real issue for patents, and the law needs to continue to evolve, and it has evolved. There's been the Morris case is cited oftentimes as being a 101 case, but if you read it carefully, I think it's a 112 case. It's just the statute wasn't quite in place. The 1952 Act came after Morris rather than before Morris to make it really, really quite clear. So from an eligibility perspective, I think it's eligible. It's a completely different question whether it's patentable. And then if it is patentable, then you want that innovation, you want new outcomes, you want new diagnostics, you want new treatment options for patients. And the pricing issue is a serious issue. Dana-Farber is very sensitive to that, but it's really a different issue.
And do you share that opinion, Mr. Blaylock, that this is not a patent issue, it's a pricing issue?
Well, I think the pricing issue sometimes follows the patent issue, because the reason why the Myriad test was $4,000 a test was because of the patents. And I can tell you that I was counsel of record in the multi-district Myriad litigation that was going on in Salt Lake City, Utah, that Myriad owned or controlled about approximately 24 patents with over 500 claims, and they were not all invalid. They continued to be valid at the time when Myriad unconditionally dropped its suit, but those patent claims were not invalid. Yes, there were 3 or 4, maybe 5 patent claims to specific genes that were invalidated in the Supreme Court case, but that had no commercial effect. They still had an enormous patent war chest, which they were asserting against the entire genetic testing industry, and hence that litigation, which was ongoing after the Myriad case. In terms of what's important to understand is we're not arguing about patents of genes. We're talking about patents of the observed variations in human genes. My genome and your genome are not identical. Some of those differences have clinical relevance. They could indicate whether one of us has a greater likelihood of contracting a disease in the future or be a better responder to medicine. Those kinds of observations are being made today on an ongoing basis. It requires aggregation of large amounts of data, and this law would allow all of those new observations to be individually patented, where the only thing that is the subject of patent is the discovery of that biological information. Now, by contrast, if one invents a new technique for getting a gene, even a known gene, into the body, so you have a new vehicle for doing this, if you have a better way of doing genetic testing, if you're Illumina and you make better machines, if you're PacBio and you make better machines, you can get those patented. But what we are talking about, the problem with PARA, is that it specifically allows this new information, which is continuing to evolve, which is understanding the details of variation in the human genome, which is not all known, to be patented and controlled in an individual way. And that will impair access, either from pricing or simply injunction.
And Ms. Peshin and Mr. Salzberg, would you like to share your thoughts on it as well?
Yeah, maybe I'll make 2 points. One is we strongly disagree with that interpretation of what PARA does. PARA, at least as we read it, it codifies Myriad. It codifies the distinction between isolated human genes, which is the only thing that case actually held is not patent eligible, and applications and modifications of genes. In Myriad itself, the court said that cDNA, for example, is patent eligible. It found that methods of analyzing genes would be patent eligible. We need to distinguish between the gene itself, which PARA does, and applications and modifications, which are really the foundations of things like cell therapy, gene therapy, and other gene-based medicine. The other point I'd make in response to a lot of these concerns is that I really want to hit this point because it's really important to consider. China, Europe, and Japan have all allowed continuously patents not only on the types of applications and modifications of genes that we're talking about here and that we're concerned about as innovators, but even on isolated genes, sequences that are exactly the same as nature, and they've not led, including during the pandemic, to any of these concerns. In fact, the coronavirus was sequenced in China and Europe just as quickly as it was here. So if they can figure it out, it seems to me that we ought to be able to figure it out here too without crippling our patent laws.
Thank you. Ms. Peshin?
Thank you. You said a lot, but I'm going to just address a couple of things. One is, I think it's misleading to say the price is because of patents. And in particular, I think to patient advocacy community and really to consumers, a lot of these diagnostics wouldn't exist without the patent. So the patent in many ways gives us something to complain about with regard to price. It really encourages investment in that type of research and being able to bring it to fruition. And I think it's really interesting in the arguments I've seen against this remedy. I really haven't seen anything about the concern for cost when you don't have the innovation at all. When you have family members that have conditions that have no diagnostics, of which the majority, of diseases that are out there, especially in the rare space, really have no way of diagnosing. And that's something that we also should consider. The other thing I wanted to say with regard to the claim that folks are just sort of bringing these things to market, they're doing it by putting their inventions under trade secret. And trade secret doesn't become public. So folks are not able to mirror and mimic. And as part of the patent application process, that is made public. So further innovations can occur. And I think all these different facets are important to remember when you think about what's being said. And then the last thing I guess I would say is, if you have a gene, a variant on a gene from a rare disease or something else, and you're able to use an existing assay to identify that, that should be a good thing. There was a study that was done by the SMU professor David Taylor, and he looked at the negative impact on investment making decisions. And in his study, he interviewed 475 venture capital and other private equity investors to study the impact of the Supreme Court cases. And 74% of them considered patent eligibility to be an important factor when their firms decide to invest in companies developing new technology. So if we continue to impede in this way, we are limiting future innovations, and that worries me from the patient advocacy perspective.
Thank you very much. Thank you, Chairman.
Senator Schiff, I should have clarified by saying I haven't gone yet. When I said no Republican had asked a question, I let Senator Hirono go before me.
I figured that out.
Yeah. So, we have some other members I know are interested. We're in interesting scheduling times right now. I want to go back and give you some context I've said this before, I'm not a lawyer, I'm a business guy, a management consultant. But I started my career in high tech as a product manager at Wang Laboratories in Boston. And that's where I understood, where I was tasked with making the decision about whether or not this really smart propeller head engineer from MIT had a great idea that we were going to make an investment in, and intellectual property absolutely either expanded or reduced my buy box for innovation, for investing. Absolutely did. Now, Ms. Peshin, you would know this, but I was a caregiver to a grandmother who suffered from early onset Alzheimer's back in the 90s. I've received training on it, and I've given training on caregiving, and from the lens of, this is also to give you all an idea of where I'm thinking beyond just the subject matter expertise that you all bring into the room, to the more practical issue. And I don't mean this to be political, Senator Schiff, but the Inflation Reduction Act had a policy in it that dramatically reduced funding, or actually cut the prices of, basically whacked pharma. And there was an immediate, measurable, more than 50% reduction in small molecule research over the course of a year. In fact, it was so pronounced that the CEOs felt it was important to go on the shareholder calls and make it clear that they had to do that because they did not simply have the money to actually fund that research. Well, similarly, if you have that's uncertainty, it's about the future flow of revenue to fund research. If you have similar uncertainty in this investment that you're about to make and a future cure, you've got all these other stressors and unknowns that are just going to continue to dramatically reduce the buy box for American innovation. Not to say that it won't be picked up in Europe for the reasons that Mr. Salzberg mentioned, and I'm going to have Mr. Blaylock speak about that as well. But I'm thinking through the lens of, number one, accelerating some of the most promising research that we can have in the biotech space, The enormous societal, human, and fiscal implications are immeasurable, which is why I feel like this is one small step in that direction that expands the buy box, increases our innovation posture here, and I think has dramatic impact on lives, both fiscally, humanitarianly, and at every level. Mr. Blaylock, why hasn't Europe experienced some of the bad things that you think happen if we do this here?
Well, first off, although I'm a lawyer, I work with business folks all the time. I work with startups. I work with folks that are trying to develop new technologies in life sciences elsewhere. So I am keenly aligned with you with those concerns. People look to the U.S. much more than Europe for as the market that will determine whether they want to pursue any particular life science technology, and that is tied to pricing, and patents are just a small piece of the ability to get reimbursement for new medical technologies. So I think the differences between the U.S. and Europe are driven by other factors, not so much by patent subject matter eligibility. But I think one thing that I would address here that I think is very, very important is the drivers for innovation. And it is this. People often talk about the cost of a new drug being $1 billion, or sometimes people have upped it to $2 billion. When I'm talking about new genetic tests, this is information that comes out of genome sequencing, which you can do $1,000 a pop. It is not a $1 billion investment by a company in order to make this information. And indeed, contra the suggestion that it's all going to be trade secrets, honestly, the clinical acceptance of the kinds of information we're talking about that we think should not be part of what would be patented under PARA is necessary, and therefore this information is not being held as a trade secret. It is being published. It is being generated today. This last 10 years has not stopped the flood of this information. Our concern is PARA would stanch that flow of innovation and make it that much harder for people to access it.
Anyone have any comment on that? I know I've kept y'all up here.
Just briefly, I would say that we're not interested in patenting genes from what we do, but what we are interested in is having clear patent eligibility laws that don't keep changing and expanding into new territory every year and every time we have a case like Regenexx Bio. And if we don't stop this, then we are now moving away from the myriad type cases into the core of the technologies that we're trying to develop for tomorrow, which are clearly applications of this. So the courts definitely need guidance, separate and apart from the debate over whether isolated genes by themselves should be patentable.
And in some respect, if a business person's watching this, I mean, this is just about eligibility. It's not about an ultimate patent being granted. Isn't that a good thing to increase the pipeline? And doesn't it seem like that there are guardrails beyond 101 that address most of the concerns that Mr. Blaylock had mentioned? I want to, as a business guy asking kind of a legal question.
One more quick response, and Mr. Kaltwriter referenced this earlier. I mean, if you read the Supreme Court case law about how broad Section 101 was written from the beginning, it is precisely because science is unpredictable. And lawmakers early on from this country's birth did not want to set the limits of where research should go. And you're absolutely right. Eligibility is just the signal that this is where you should invest in general. And from there, the rest of the Patent Act will narrow down what's patentable and what's not.
Mr. Cartwright, or anybody else for closing comments? We're going to close out the hearing.
Yeah, just very quickly, because I think that Mr. Blaylock makes a good point in terms of new information continuing to evolve. I mean, with the artificial intelligence and the data management capabilities that we currently have, there is tremendous innovation occurring. But I see it nearly every day, and I had a call with the head of the business development group at Dana-Farber this morning. She can't get any interest in terms of trying to form a new co, trying to license it out. If it's a diagnostic, and that innovation is relevant to a diagnostic, it's a hot potato and no one wants to touch it.
Well, you all, thank you Thank you for being that. That's really what I'm concerned about. I want to get more in the pipeline, and I am trusting that the ultimate decision on whether or not to grant a patent has sufficient guardrails. At the same time, I want more innovation. I want more cures. I want more AI algorithms. I want more outputs from the U.S. economy to maintain our lead. We're about to conclude this hearing. I did mention in my opening comments, I kind of hope this is the last hearing on PARA before a markup. I'm going to do everything I can to move this bill. So, Mr. Blaylock, to your point, I have thoroughly appreciated your prior testimony and the experience you bring to the table. I'm going to do everything I can in cooperation with my colleague to move this bill forward and to get a markup. And so you should assume that there's at least one person who's going to be very focused on this, and therefore it will be moving, and we would appreciate your feedback on how to address the concerns that we can. This has been another very helpful committee. We're going to keep the record open for a week. We would encourage you all to submit any other papers or documentation you would like for the record, and be on the lookout. I've got to talk with the ranking member, but I think most of you all that have participated in any of our work groups, I really kind of prefer the work sessions to committee hearings because we can really get into a collaborative mode. So be on the lookout for an invitation to participate in that as we prepare to gain support and ultimately move to markup. Thank you all for being here.